Happy Tuesday, everyone. Thank you for joining us this evening for the Creative Finance Collective. I'm Sean St. Clair, and I'm here with Alan Sesker and Drew Jenkins. My law partner, Andy Fowler, is off enjoying some pleasant weather right now while he's on vacation, and I'm here in Sheboygan, Wisconsin, where it is snowing outside. So I wish I were where Andy is, enjoying some sunshine down in South America. But nevertheless, I'm in charge of the show tonight. And so I'll do my best to keep up. But if you haven't already done so, jump onto our YouTube page, give us a like, go on to our Facebook and subscribe. It's the NRIM podcast. There's also a QR code at the top here where you can go and connect to our YouTube page by just simply clicking on that QR code, and we'll take you right there to YouTube. We have tons of content and other things on there. We do basically two shows every day, not every day, every Tuesday. One is the NRIM podcast at 10 a.m. Arizona time, and then this show, which is the Creative Finance Collective, which we do at 3 o'clock Arizona time. So, if you have questions, go ahead and post them in the comments, and we will get to them. We're going to chat here amongst ourselves for 10 or 15 minutes and see what questions roll in. If we don't have any questions after 10 or 15 minutes, we'll wish everyone a good night and go about our evening. So feel free to jump on and start asking those questions so that that's how the show will go on longer. All right, guys. Hey, how's it going?
Doing well.
Yeah,
it is doing well. I'm glad that we're finally not getting below freezing again for a while here. I know you've got snow where you are, but it has not been pleasant in Georgia here lately.
Yeah, that's what I have discovered. I have a friend that's down in Mississippi, and we've been texting back and forth, and it is really bad down there. He's basically like, I haven't used my car in 9 days because we just don't have the equipment to clear the roads and all that good stuff. Versus up here, we're used to it and we have everything to get the roads clear, and it isn't that bad, even though there's a lot of snow and it was freezing at some point. What about you guys, Drew? Have you been able to drive around, or you kind of kept the car just parked?
Yeah, no, we haven't had any precipitation. So, I mean, it's just cold.
Good.
It's just bitterly cold, at least from our perspective, right?
Yeah.
It's been pretty rough. But I actually had a question for Alan. So,
Yeah.
I noticed last time there was some kind of flyer or something in the back about some kind of seminar that you're putting on. So I went and looked it up. Can you tell me a little bit about that and kind of what you're doing?
So I call it Rap University. It's a 4-hour continuing education certified program. And it really just takes every single thing that I've ever learned and experienced and dealt with in regard to mortgage wraps and subtos, and boils it down into a like I said, 4-hour program. There's an online version, and there's 19 modules, but they're little 6, 7, 8 minute modules. And so it's in theory designed to take someone who doesn't know anything from absolutely start to finish. It is a lot of material. I've gotten feedback that when someone is brand new, they come out dizzy as opposed to extremely knowledgeable. But it's just my little Rap University course.
So Drew, I'll give a plug. January of last year, I got on a plane, flew from Phoenix to Dallas, and attended the Rap University in person, and it was worth that plane flight. It was worth the cost of attendance. It really does add to your repertoire, and it gives you some skills that, frankly, you probably don't even know you needed. So definitely something to look into. I've put the QR code for Rap University up here in the top left, so you can click on it, or anyone in the audience can click on it, register, go attend in person. I think Alan also has an online course. I learned better in person, so I liked going in person. Plus, I networked with a few people and, got to chat with Alan. And in fact, the insurance agent that I recommend, and he can write some stuff in Arizona, so I refer him all the time. I met him at Rapp University. Mike Monzingo is his name, and he does a little presentation at Rapp University and really teaches you how to structure the insurance for the subto transaction or the Rapp transaction the right way. And it really is the right way. And he knows how to do it. And so it's just those types of things that I think the in-person attendance gives you that you can't really get, online always.
So is it geared towards attorneys or real? Because you said it has CE credits. Are they realtor credits or are they attorney credits or both? Maybe.
So just realtor. And I have learned that it's probably overkill for a realtor. And so I've developed another presentation, a little 1-hour presentation. It's called Investing for Realtors. However, about 30 minutes of the hour is dedicated to going over mortgage wraps, but more just a high educational intro to them, as opposed to the nuts and bolts and how to do these things day in, day out. So it's probably investor based.
So we do have a question.
Yeah,
Drew, definitely. I would definitely attend. And the link is up there. Do you still do them in person, Alan?
Yeah. So the next one's in person, and we're going to have it Zoom for the first time. And so it's in person in Austin and then Zoom.
Very good. So we do have a question, and the question is, hey, do you guys think a wrap is overkill on a subto transaction? Since we were talking about Rapp University, I'll let you answer that, Alan.
So I'm going to assume the question is asking, hey, do we need a full set of mortgage loan documents for a subto, or is that overkill? The way we used to do a subto is a deed to secure assumption, and that was it. And we've grown to where we know, all right, we need a promissory note so they can use that to help them with the DTI issues, their debt to income issues. I want a right for the seller to recover the property if the investor or buyer defaults. I think it helps legitimize the transaction. If you get in front of a judge, they're going to want to see a set of loan documents. So I don't close anything unless it has a full set of mortgage wrap documents, even for the subtos.
Yeah, and I'm in your court on that. I'm in your court on that. I don't do just subto with warranty deed only. I want to have some remedy that the seller can pursue in the event that payments aren't made. Whether they pursue them or not, I don't know, but at least they're there. And I think judges too, like you said, it adds legitimacy to the transaction, because wraps have been around forever. So you get in front of a judge, you're like, we just did a wrap, it was a wrap. And judge, oh yeah, I know what wraps are, Now, one thing though, and you guys can't do this in Texas, but in Arizona, we can do agreements for sale or contracts for deed. And in that case, I have an agreement for sale form that is basically a one document, which is, that's it. And it is your purchase contract. It's your loan document. It's your security document, and it's one form. And the way it works is you basically open escrow with the agreement for sale with non-notarized signatures. And then you have all of the escrow terms in the document. And then when the parties go to close, then you notarize a secondary page of the agreement for sale and you record that agreement for sale. So it's one document, and you record it, and that's it. That's the transaction right there. And so that's a simpler way of doing it. Obviously there's, the agreement for sale, in my view, is a lower risk of a due on sale issue, especially on VA loans. In fact, the VA handbook says that they don't consider those to be an alienation. But they're a greater risk for bankruptcy because they're still an executory contract and be set aside in bankruptcy. But if you want a simpler way of doing it, I would encourage the contract for deed or agreement for sale, which, like I said, is and should be structured, in my view, as just one document, and that's it, and you're done. Like, that's a transaction.
We had those in Texas before 2005, and then they changed it. They are simpler.
Yeah, they are simpler. All right. Can I introduce a subject to during escrow? Okay, so it says, how can I introduce a subject to addendum during escrow if it wasn't part of my original purchase contract? Drew, you do a lot of closings. You want to address that? Like, hey, I didn't get that subject to addendum signed. Now I want it signed. I'm in escrow. What do I do?
Well, I hope you're good at negotiating. Right? I mean, you can always do anything so long as the parties agree. I mean, within reason, and
Right.
obviously some state, there's limitations. But, if you want to take over the seller's mortgage, and give them some boot, right, to make them happy, depending on who they are, that might be thrilled to hear that. Otherwise, they might say, no, I want my mortgage paid off because I want to buy a new house. And obviously I need my credit, right, to not show my debt to income ratio. So if you weren't upfront about it at the outset, depending on your seller's financial condition and how well you explain what a subject to is, they're either going to be thrilled that, you're going to do this, or they're going to say, I wouldn't touch that with a 10-foot pole, pay off my mortgage, let's move forward. But that's not something that you're able to control, but it's something that you're going to be able to negotiate.
Yeah, I think it comes down to really going in there and basically going to the seller and said, oh, we should have executed this, because presumably you've already had the conversation with the seller about the nature of the transaction. In that case, then you should be able to go to them and say, hey, let's execute this. And assuming they're agreeable, then you can get it done. All right. Can I use someone else's proof of funds? Is proof of funds common in sub 2? Does somebody want to touch that?
So I'm going to say no, and it's because of someone up in the neck of the woods up near Scott Horn, a Louisville guy. Now, he wasn't using someone else's funds, proof of funds, but he doctored his proof of funds, and then he got into a bunch of trouble. I think if you're saying I'm ready, willing, and able, you're saying I am. And now, if you want to disclose, I have proof of funds, I have a private money lender, and here's their proof of funds, sure, but not. I wouldn't try to secret it.
Oh, heck no, Alan. And by the way, investors try to do everything and anything in the book, you name it, they'll try to pull any fast one. We already know that. And what I find intriguing, though, about subject to type transactions is sellers rarely, if ever, ask for financial information. I will tell you, 1 out of the last 1,000 may have asked for some kind of application from the buyer. I just find it very intriguing that on a seller to investor deal, there's almost never a personal guarantee. There's no financial information exchange, at least that I see, at the closing or I'm aware of. Maybe behind the scenes that happens somewhere, but it's just intriguing that it is never brought up.
Yeah.
Well, and to answer the secondary question, there is proof of funds common in sub 2. So obviously proof of funds is a negotiated term. I mean, it's not a standard provision in the contract. You normally are going to, write that in, or a good real estate licensee will fill out the contract and write that in, or a good attorney will write that in. Sub 2, normally you don't, in my view, unless there's a sizable amount being paid to the seller, normally you're not going to require proof of funds. Maybe an assignor may want to require proof of funds if there's an assignment related to it. But otherwise, generally there isn't proof of funds necessary in a sub 2. You guys agree?
Yep.
That's what we see out there mostly.
Yeah, so long as they're not trying to use, like, again, our forms are generally state, we use GAR forms for almost everything. And I have some wholesalers and investors that just prefer to use the GAR form and then tack on their own special steps, right, to make the deal work. The GAR forms, if they're using that, that does actually have an addendum if you're saying that you're coming in cash that provides a proof of funds provision, which is just part of our standard document. So like you were saying, it's going to depend entirely on whose documents are being used. I don't think any of the actual wholesalers' internal docs contain, a proof or verification of funds. But I do know that if they're using the state standard forms, that does include verification of funds provision. That can be, you're not required to provide it, but you are required to provide it if the seller requests it. And these are how many days you have, and this is the form that it has to be in. So it's pretty highly or tightly written, which is good.
All right. So a question out here. Is there such a thing as due on sale clause insurance? Anybody aware of it?
So I just now had a meeting 2 hours ago with a group of folks who are going to provide due on sale, and it's called assurance, not insurance. And I've always been kind of hesitant to believe in this thing, but I think I'm actually going to join on because it's I would call it due on sale protection, not due on sale insurance. There's different levels that you can try to fix a due on sale clause issue, whether it's caused by insurance not being put in place correctly, maybe move over to a trust vehicle. There's different levels you can go to fix that. And I think instead of me just doing that for free on my own transactions, I may actually join with them and be part of the due on sale protection that they're getting ready to launch.
Well, let me kind of throw my 2 cents for a minute, because this has been out there for a while, and there are a few people who say that they are due on sale insurers or assurers, as you point out, Alan. And of course, my first comment is what's behind the company doing the insurance? Who is the person issuing this particular guarantee? And read what it is they're providing you. In other words, before they step up and write a check to pay off this underlying loan, do they have the financial ability to do that? Well, if it was just one deal, maybe. But what if they got hit with 10 or 20 deals? I think Alan pointed out there's a few sidestepping mechanisms that we get a chance to go through from time to time that helps us to, dance around due on sale, which never goes away. And I look at it as a ploy sometimes to convince people to do subject to deals, to try to take away the risk that's involved of that loan being called due. But what is the financial ability of company X, Y, or Z to fund these deals appropriately? Are they really backed by Lloyd's of London or somebody down these lines, or some major net worth that allows them to do that? And then how many times are these guys going to step up and write a check on a 3% interest rate loan to make it go away? So I think you need to read the fine print in whatever it is being presented, see what's being offered before you step out and pay for something of this nature.
So, Alan, I actually had a question on that as well. So who is the insured? Is the insured the seller? Or is it more like title insurance where the insured is the buyer and you're just basically guaranteeing they get their money back, right? Because I think that you could write it 2 different ways. I mean, to Scott's point, you could pay off the primary mortgage, or 2, just like title insurance, you could just give them the money they paid, right? And then let the foreclosing or the due on sale clause do whatever it does to the seller. So who's the insured, and what is actually being insured? Is it the property and paying off the mortgage, or is it the returning the buyer's capital?
My new interest in this is based on the handful of times that I've had to come in and fix my own transactions. And my quote is, I stay married to my mortgage wrap transactions for the life of the transaction. And so when there's a problem, I come in and fix it, and I'm billing $0. And I've looked at the business model, billing $0, and it doesn't look like it has long legs on that. And so my desire is to monetize what I'm already doing, and create, I would just call it due on sale protection, not insurance at all. So to answer your question directly, my goal is to protect the transaction, not buyer, not seller. And we've never had to go to the step of paying off the underlying mortgage. The preliminary steps always worked.
Well, I'm just going to make a comment, Alan, real quick. For instance, in our offices, when we close a transaction, we're done. We've closed the deal. All parties are taken care of. Of course, buyer, seller, whoever it might be, is supposed to have the je ne sais quoi ability to deal with that deal going forward. If due on sale arises sometime thereafter, that ain't a legal freebie, because there's a lot of hoops, a lot of paperwork to be done. And it's just an added expense that either the investor, the homeowner, or someone else has got to put up in order to attempt to cure that, with the caveat that even though you go through all these hoops, which has worked for the past many years along the way, it doesn't mean that the next time we step out and do it, that it will work, unfortunately. So, from our end, we're billing for that up front. Just because
I think that's a better business model.
Well, I'm thinking that down there in that Austin area, at that junior college y'all have down yonder, they teach the wrong thing from time to time.
Yeah, I like that.
This is
So
that ag thing we do from time to time. Even though Alan's not that persuasion. But I'm just going to make a final comment about this due on sale insurance. It came out a couple of years ago, and it's kind of like the performance deed we've talked about before. Everybody tries to find an angle in a business to monetize something or to market something. Do the deal. You can do these deals. You can buy subto insurance, as they try to say it, or subto assurance. There is no such thing, I don't think, that exists out there. And if there is, what's behind it? Read the paperwork, move from there. But it's just looking at the various options and ideas. Everyone's trying to find that angle to sell something to somebody to entice them to do a deal. And bottom line answer is just educate yourself, know the risk factors, see what's out there. And if it's a legit business that offers the insurance, go for it. If not, assume the risk and move on. I think we all agree the risk is fairly minimal, but you never know.
All right. We have another question here from Walter. He says, can the seller sue after closing on a subto to state that, or I guess it would be any transaction, to state that they were treated unfairly? If, say, for example, you bought a property for $50,000 and turned around and sold it for $200,000.
My response to that is the same response I always give. Anyone can sue anyone for anything at any time. But to drill down a little bit further on it, my answer is yeah, if you have overreaching, if you have unconscionable conduct, then that could support a cause of action. So if your deal is too good, and you're going to take into consideration the parties. You have a real estate investor that's closed 500 files, and then you have ma and pa who have their one house they've ever purchased, and you go and your deal is too good. It could cause problems, in my opinion.
Yeah, and that's the thing for people to understand is that there is no gatekeeper at the courthouse to open up complaints and documents that are filed and say, oh no, this one's no good, we're going to throw it out. This one's frivolous. No, it gets filed, it gets served, it gets litigated, and a decision is made. And unfortunately, we're not cheap. Us attorneys are not cheap, right? I mean, we have hourly rates, we have retainers, we have fees that we're going to charge, and it's not going to be cheap. So, the best thing to do, and like you said, Alan, is to, you're an investor, and obviously your role is and goal is to be profitable. But if you're overreaching and you're going way beyond that, that potentially can create problems. So you just have to be careful on, how you structure these transactions and the, establishing the right amount of consideration, the right, making sure it's not an unconscionable type transaction.
You can make a lot more than that in a deal. I've had a couple of deals recently, and in one, this is a commercial deal, but the spread on the flip was $2 million. And it ticked off my client, who was the developer. And he forced, I forget how much, but I mean they did very, very well. The wholesaler still made over $1 million. And I had another deal that was residential where my wholesaler bought it and was flipping it to a government entity, and their spread was in the six figures. And part of the concern that they had was exactly your question of, and of course they didn't want to disclose it, but obviously the government has their own attorneys, and they wanted to file the paperwork. And I'm like, look, like, their lawyers are going to see what your spread is, so you might as well just come clean what it is. And the funny thing is, in hindsight, the government already had a private buyer lined up to put the assemblage together, and they're like, we don't care that you guys made a $200,000 profit. We sold it for $3 million. Right. And so, I mean, you have to be aware of who the parties are in the transaction. So you can definitely literally make seven figures if you have the right parties in the deal. But you do need to be careful because, as Alan said, if you're also engaging in some activities that wouldn't sit well with a judge, you could be opening yourself up to potential liability there from the seller's end. But it's definitely not impossible.
And guys, I agree with that. No, usually what I see the issue arises on is when it's an investor buying a property from a seller, who the seller is, and they're assigning that contract to a third party for this very large fee, and maybe it's a investor to investor assignment or whatever it might be along the way, but they don't want that seller to know what they're assigning it for, because if the seller sees it, of course, they could possibly nix the transaction. So many investors don't put proper language in a contract where they can assign a transaction without any issue. And normally you see these in commercial deals where it's dog eat dog, not so much in residential. But if a seller thinks you're making too much money, could they possibly not allow you to assign it, even though you have those little magic words and or assigns in the contract? It's possible they could do that. So I see that mostly on the front end versus on the back end. But at the same time, if some investor got just a screaming hot deal out there, are they allowed to assign that, sell it, and make money on it? Sure they are. At the same time, you don't want someone out there overselling a property by 150% of the value to somebody that could then be deemed to be taking advantage of them in some form or fashion. That's where you might buy that lawsuit I think Alan was talking about.
Scott's point, that reminded me, Sam's Club will absolutely look very, very closely at any assignment, either of your contract or of if you're trying to assign membership in your buying entity. We had that happen. Two guys had a great deal on a defunct vacant Sam's Club, and they had it under contract, but they realized they had bitten off more than they could chew to take it down. And they attempted to assign it to someone else, and Sam's Club was just like, absolutely not, unless you take literally nothing. And so then they thought they were clever, and they tried to structure internally, and just be the managers of the buyer, but basically sell the interest of the buying entity to the fundamental buyer. And I forget, I wasn't the main attorney on that, but somehow Sam's Club figured that out too, and they scuttled the whole deal, and they told the end buyer, how about you just come deal directly with us, right? Since these jokers couldn't take it down. So yeah, the commercial world is definitely a bit more dog eat dog.
So the next question here is, what is the most common mistake you see made on subto transactions? I will say for me, it's properly structuring the purchase price, not having adjustments in the cash at close, in the purchase price, in any type of secondary seller financing to adjust based upon the payoff of the loans at closing. That's the biggest mistake I see is the loans come in for $20,000 less than people thought they were. And then you go to the buyer and say, okay, 20 additional cash at close to meet the purchase price. And they're like, well, wait a minute. No, I didn't agree to that. I want to bring in this cash. It's like, well, the purchase price is static and the subject to loan has adjusted, and now somebody has to make up the difference. And so, to me, that's the biggest mistake that I see. What about you guys?
I adjust for that in my contract document where.
Well, yeah, of course you do. But that's the mistake that people make, is not using your documents or Alan's documents or my documents, that's the problem. What else, Scott? What other mistake do you see?
Give me about 2 minutes. Let me think about that, and I'll tell them to you, okay?
All right.
Tell them plural, right?
It was.
Well, Drew, Alan, what do you guys think?
Well, on mine, I'm not going to say the most common mistake. It's I'll call it the worst mistake. And that's not utilizing, and you said it earlier today, not utilizing a knowledgeable, experienced insurance agent, because you have to get the insurance sent over to the mortgage company correctly, or the mortgage company is going to start poking around, and then they'll start calling the note due, and we've got problems. So that's the biggest issue that we deal with. The other issue that I'm going to say is not necessarily a mistake, but if it's not papered up correctly, escrow refunds and insurance payments. If you don't have your authorizations and your power of attorneys and those things in line, you're absolutely not going to be able to get those things managed correctly, signed off on, deposited, et cetera. Even when you have your documents all squared away, it's still difficult sometimes. So that would be another, what I'd call headache, not necessarily a mistake, but a headache.
Yeah, I see guys, out there, mine is, I see so many guys, they don't understand what is out there against the property. They haven't done their homework up front in looking for underlying liens, such as a HUD partial claim deed of trust or a down payment assistant lien or other kind of liens that can be out there. They haven't done just the initial homework out there. So they get down to the closing and the title search or the title commitment comes in, and all of a sudden all this stuff blossoms and it's like, oops, we got a problem. And they don't know how to navigate that. I also see a lot of investors who they just jump up and call the lender calling in for a payoff or other things. They'll send in power of attorneys or authorization forms. In all honesty, I don't like that. I want if I'm buying a home subto, I want to work with the seller to call in and request it direct. I want to put that lender on as little notice as possible that there's anything going on in the back end whatsoever. Because the moment you start sending in power of attorneys and authorization forms and things of this nature, all that stuff gets saved. It pops up on the screens out there. And I'm also seeing this dual authentication nowadays going on. And so if you want to get something done with the lender, they want a dual authentication, whatever that might look like. So you got to make certain that as you're buying that home subto, you're able to go online, set up your online passwords, change your mailing addresses appropriately so you can navigate the mortgage properly and any changes that might be made. But also, when requesting other information from the lender from time to time, they're going to want to text you something on the cell number, And if you haven't changed that, you're not going to be able to authenticate that at all. So I agree that the things with Alan are important from insurance, which is probably the number one thing that's out there. But I think understanding some of the basics, I just think so many of the people in this industry, they get a modicum of knowledge and just jump right into it. And then they think whoever else they may be working with, such as transactional coordinators that are out there, that these people are going to solve all the problems for them. And unfortunately, I find out that oftentimes these TCs don't know any more than the investor does. And you wind up again with that blind leading the blind scenario.
All right. So our next question is there anything to watch out for if buying subject to at an auction? I don't know that I've never heard of buying subject to at an auction. You guys heard of that?
Well,
No.
you can buy a second lien.
Okay.
Yeah. Subject to the first, what it might be. But again, that's buyer beware, right? Because a lot of investors think that just because you bought the property at the auction and work from the second lien perspective, that the first lien holder is automatically going to work with you. And they don't have to. They may or they may not. And it's kind of luck of the draw there a little bit along the way. But no, their borrower is no longer their borrower.
Yeah, that's interesting. I don't know what Texas law provides, but Arizona law provides that basically any successor and interest to the property by way of purchasing property at a foreclosure sale has a right to make payments, to get payoffs, to get reinstatements from any senior lender. And just because they're not the borrower, the law provides they have the right to do that and to make, payment, to keep the loan current, all of that. And so that's interesting. I think it's actually an interesting investment strategy, and have talked or worked with clients to purchase second position liens because, think about it. You can, with very little entry fee, you can pick up a property through a foreclosure on a second position loan. And then you don't have to worry about a hard money lender. You have the first out there, and all you have to do is, either reinstate or keep the first current at whatever low interest rate it is while you do your, modifications to the property and that type of thing. So it's not a bad investment strategy. You just have to make sure that, if you get pushback from the first, at least here in Arizona, if you get pushback from the first, you need to know that those statutes exist and go to the first and be like, well, Arizona law says you have to give me this information. You have to accept my payment. You have to let me reinstate, all of that. And knowing those laws.
I think that's awesome. And you guys in Arizona are weird. Out here in Texas. I don't
because I had that issue. Yeah, but I had Scott's issue. It was Regions Bank. Sorry, go ahead, Scott.
No, I was going to share a current horror story with you guys that involves a second lien foreclosure. I performed for a client out of California, foreclosed on a second lien on a property here in the DFW area. And I could have sworn I would have had 0 bidders on this thing at the auction, but I had several bidders on this thing. And this one fella bought the property. And he wasn't a novice at all to the foreclosure auction. He had bought several other homes at foreclosure in the past. And what happened in this case, I don't know. I can't believe he was buying a property that had a value that was in excellent condition, that had a value of probably $600,000 to $650,000 for $100,000. You just don't buy a property in DFW like that. And so, again, it's buyer beware. So I know he had to have known he was buying a second lien. Well, the first lien just happened to be an Arizona hard money lender. And he's calling, wanting to know information about who that lender is, which we had it, so we provided it to him. And he almost immediately started calling me back, asking us to unwind the foreclosure. And of course, I'm just going, I hate to tell you this, but no can do. I don't have that authority. I'll be happy to talk with the lender and see if they have interest in doing that, which I think we all know what that answer was. And this guy proceeds to do this for 90 days, y'all. He probably sends me 30 texts and emails asking me if there's any way of doing this. Eventually, he winds up asking if our investment company would like to either finance the property for him or buy it. We made our offers to him. He rejected them. And I believe that the first lien holder in this case foreclosed. He had the option to pay the first lien holder, I think. They would have taken his money, but they were really looking for a payoff in this instance. And so the gist of this whole thing happened is after they foreclosed, this Yahoo goes out and now claims that the cashier's checks that he presented to me personally at the auction and endorsed them in front of me were forgeries. And so, of course, his lender immediately requests the money back from our bank after we've already had this deal fully funded to all the parties involved. So you can imagine we're in a lawsuit now. Luckily, we got the funds diverted to the court registry and got the injunctive relief we needed to move along the way. But that's just a second lien option of things that can happen, that you have to know what you're doing before you go out there and start playing this game at an auction. But it's awesome to know that in Arizona, y'all can do that kind of stuff, Sean. That is a good business.
Let's hold on. I may be usurping some of the questions and wants of our listeners here, but what if you're an Arizona investor? You purchased a Texas property. Can Arizona law protect you and get you that information from these lenders? Because it's a real problem here.
Yeah, I don't think so. I think Texas law is going to govern 100% in that case. But the problem
is, like
is,
they did in Alabama, they threw up federal law.
Might know Arizona law and think that that's going to apply to Texas, and it's not going to. I don't believe.
Well, if I can trick someone into getting me that information, that's just as good as convincing them.
Are you saying you're going to trick somebody?
So
That phrase.
let me ask you guys a question on that, which is interesting. Now, the Garn-St. Germain Act applies to residential property and, any federally insured loan. And it very clearly says that second position deeds of trust would not trigger due on sale. So wouldn't the logical, and I haven't researched this, and maybe you guys have, wouldn't the logical next step would be, well, if the second forecloses, that shouldn't then trigger the due on sale as well, because the due on sale shouldn't have been triggered on the initial alienation, which is putting the second position lien in place. Wouldn't a foreclosure on the first, as a result of that, not a monetary default, but a default in, a transfer of the property through buying a property via foreclosure on a second, when the second was allowed by Garn-St. Germain? I don't know. Does it flow down, or would it flow down to a buyer who acquired the interest through that second position loan that was allowed?
Well, let me ask you a question, Sean. I know Garn, but I have to admit I have not read it out there at all per se. So are you saying that placing a second lien on a property doesn't effectuate due on sale? Or are you saying
Correct.
that Garn-St. Germain says that if the second lien gets foreclosed upon and that the borrower is no longer the same borrower on the first lien mortgage, that they still can't effectuate their due on sale?
That's my question. I don't know the answer to that second one. I know that obviously a second position loan can attach without the due on sale clause being called,
Yeah.
But shouldn't the logical, next step be that, well, that would also include somebody who acquired the property through a foreclosure of that second position loan, right? I mean, that would be taking it to its logical conclusion, I would think. But
That's because you're a lawyer, not a lender. I think the lender's going to come back and their argument's going to be that the person whom they had entered into contract with on that mortgage is no longer their borrower. And we don't have a statute that you guys have in Arizona where it says so long as, there's not a diminishment of the ability to pay or the collateral, that first lien holder can't foreclose. I think in Texas, they can do it, but that might be an argument to be had in Arizona because of some different rules and regulations you guys have.
Because I ran into the same issue that Scott and they were talking about years ago when I was a young attorney. We had a someone who had immigrated to the U.S. and she bought a property subject to Regions Bank had a mortgage on the property, and they said, "You're not our borrower, right? You know, Financial Privacy Act. We can't talk to you." And I mean, she had to sue them in court to get a payoff out of them because according to Regions, you know, she's not a borrower and they're prohibited under, you know, law of disclosing financial information, right? It's all that NPPI nonsense that Trid gave us.
No, I can see that. That's where you have to have those POAs or authorization forms. And hopefully you contract and purchase your home properly to have those items to alleviate those issues.
All right, I think we've kind of beat this one around enough. Let's take a look at another question here. Can someone record a memorandum when they're wholesaling?
In Alabama, you better record it.
At least here in Arizona, if you have legal authority or authority by the contract, you can. If the contract doesn't say that you can or doesn't allow it, then you're not allowed to record a memorandum. But the one thing I will caution is this a contract that you truly intend to perform on? I think that is always the question. You know, we have situations here in Arizona where people actually, it's their business model. I wouldn't even call them investors. I would call them scammers, but their business model is to enter into purchase contracts for amounts that they know are greater than the fair market value of the property, record a memorandum, then don't perform. And then when the seller goes to sell it to somebody else and title picks up on it, say, "Oh, well, that's $5,000. And then it's a question of, well, do we go into court and, you know, pay an attorney $5,000 to $10,000 to get that memorandum released? Or do we just pay it at closing and be done with it? It's unfortunate. I don't like it. But if, you know, you're legitimately there to sell the property and you have approval from the seller within the contract, or you have notarized signatures on the contract, then you can record a memorandum or even record the contract if it's, you know, properly acknowledged as required by Arizona law. What are your guys' thoughts?
Well, if you're wholesaling or assigning, my opinion is you can file an MOC all the way up until you assign that contract. Once you assign that contract, you don't have the contract to support the memorandum of contract unless your assignment agreement allows this in some form, but most don't. I would say you'd have to release your MOC because you're no longer the buyer and you don't have a contract supporting it.
Yeah, I mean, I guess that's interesting. So if you're saying if you record the memorandum, then you assign it, you need to release your memorandum at that point?
I think that's the contract law.
Yeah, but the problem with that, and by the way, I'm not disagreeing with you, Alan, is, you know, these Yahoo investors out there who want to play this game, who don't have the ability to close the deal, but they want to try to make a buck and hold everybody hostage. You know, you can threaten them with whatever you want to threaten them with, but they don't have any money, any resources, and, you know, there's no real ramifications, unfortunately.
Yep.
And that's just the real life perspective of this whole thing, which is what really stinks.
Yeah,
I mean, normal transaction where that was the case, where the buyer thought he was going to wholesale, and I represented the seller on this and the listing agent, and he backed out because he never actually had the funds. He was some young kid out of New Jersey, and you know they wanted to sue him, and my response was, he's a kid in like New Jersey, right? Like you can't force him to buy a $450,000 house, right? He doesn't have it, and he's in New Jersey. So I mean, it's exactly y'all's point. You have people who have no ability to actually perform signing contracts, and your ability to deter or mitigate that is extremely limited.
Yeah, and here's the other side of the coin, which is, I mean, these investors are all sourcing the same or similar databases. They're all communicating or contacting the same sellers a lot of times. And so you have investors that are then always trying to undercut each other, and, take these transactions from each other. And so as a result, if you don't record the memorandum, you can't really establish your equitable interest, your contract interest. And if somebody comes around and, buys it out from under you and closes before you, they very well, assuming you can't prove that they knew about your contract, you can't, then unwind that transaction and you're kind of hosed. So, it's kind of, you're in a tough spot. But I would just say, hey, if you're legitimately in the transaction, that, if you can't assign it, you can still perform, and you have the proper authority required by law of whatever state you're operating in, or where the property is located, then, yeah, you can record the memorandum. All right, let's move on here. We have a few more minutes and a few more questions here. Here's a good one. What is my next step as a buyer on a subto deal if the lender calls the note due? So you own it, lender comes out of the woodwork, calls it due. What do you do at that point?
I'm gonna start with the first answer, and that's ignore it. And what I mean by that is you've got a correspondence, and so on a couple of occasions we've ignored that correspondence that's saying, hey, we see there's a transfer, you need to tell us what's going on, what have you, or show that our borrower still owns the property. They even talk about conveying the property back to our borrower, but they're not going to act on that yet. So I tell it's very rare that I say this, but I tell my clients to ignore it first. And then step two is to decide what you're going to do. Pay off that underlying mortgage, do a deed swap and show the lender, maybe put it into a trust. Each transaction will have a different exit.
And I agree with that. I mean, there's time to do everything. There's never an issuance where you have to act immediately. And that way, it may go away. It may not. No, I usually wait to the second or third demand before I do anything and start spending money to fix the problem. But you never know what the outcome is going to be.
Yeah. So in Texas, you guys are a little limited on some of your remedies. In Arizona, you could ignore it, or if you want to be proactive, the two things that we've utilized here in Arizona to deal with those scenarios is first an agreement for sale and contract for deed. So we go ahead and basically put the title back into the borrower's name, and then we do an agreement for sale, or that's what we call them, but they're also called contracts for deed. And we put that together, basically containing the same substantive terms as the original seller carry wrap financing, or we do a lease with an option to purchase, or sometimes a lease with an actual purchase contract. So we don't even call it an option. It's just a sales agreement. And we put that together and do a 3-year lease with the right to renew for successive 3-year terms. Once again, this is the whole Garden St. Germain, right? You can lease property for 3 years, for 3-year terms without violating due on sale, as long as it doesn't have an option, which is why then we call the sales agreement, we don't call it an option. It's just a purchase contract with an extended escrow. So we do that because I've never heard of a lender calling a loan due based upon a buyer or a seller entering into a purchase contract for the property. And so those are our two options. So agreement for sale, contract for deed, or lease, 3 years with renewals of 3 years.
Have I actually seen
and
that yet?
sales agreement. What?
Where a lender
Sorry,
calls a
Scott.
loan due because of an option agreement?
I've not seen that, but the Fannie Mae Freddie Mac due on sale clause, as well as the Garn St. Germain says you can do a 3-year lease as long as it's not with an option to purchase. So we don't do the option. We do a purchase contract with a memorandum of the purchase contract with an extended escrow. So yeah, that's what we can do in Arizona. You guys in Texas have a little bit, different story with not being allowed those two vehicles. So you kind of are stuck,
Why is this
doing
better?
some other stuff. I'm sorry, what?
Why is this better than this kind of stuff? Right?
Can't hear.
You know,
I didn't hear you, Scott. What?
why is this better in Arizona for these kind of transactions? I know everything in Texas is bigger, and man, all of our compliance issues are a lot bigger.
Well, and that surprises me because, I've always thought Texas to be the model conservative anti-regulation state, but it seems like you guys are almost bordering on California style with these transactions with all your regulations and stuff.
It feels that way, doesn't it?
Oh man. All right. Well, we've hit the hour. I know there's other questions here that we didn't get to. So if we didn't get to your question, come back next week. We'll be here for the collective on Tuesdays at 3:00. So jump back in next week and we'll be happy to follow up and answer those questions. But gentlemen, thanks for being here this evening, and enjoy the rest of your week and have a good night.
See y'all soon, guys.
We'll see you.
Bye.